Congress is considering modifying the Foreign Intelligence Surveillance Act, and that provision is on the table this week. Tell me about some of your concerns with that bill.
Congress has on its plate several proposals to grant immunity to the large telecom companies for their participation in the government's warrantless surveillance programs. Now, these surveillance programs have involved blanket gathering of Americans' telephone calls and emails, deeply private communications about matters that have nothing to do with the government and nothing to do with national security. So these are programs that deeply trench on, that deeply implicate Americans' privacy rights. And immunity for the telecoms companies would in effect stifle accountability for violations of those privacy rights.
Despite those concerns, both the President and his Director of National Intelligence have stated publicly that this immunity is vital to protect America's national security interests. What do you say to that?
The administration and the Director of National Intelligence have made a number of national security arguments in favor of telecoms immunities. And in my view, none of those arguments hold water. Most importantly, what the government has said is that if the telecoms don't get immunity, they'll stop cooperating with the government. Well, the law already provides for a number of ways in which the telecoms can cooperate under and within the bounds of the law to help the government in conducting national security activities. And there is no reason at all for the telecoms companies to get extra legal immunity for what they can do within the law.
If the government came to the telecommunications companies and told them that this information was necessary for America's national security, why should those companies be penalized for having cooperated with that request?
Two reasons. The first is that the law already foresaw this situation and said that if a telecoms company is approached by the government and asked to conduct or help with surveillance, provided it gets a certificate from the government saying the government believes this is lawful, there's no problem. And so the only reason that immunity is even an issue today is that the telecoms apparently didn't even bother to take that elementary step. They flagrantly not only set aside the law, but flagrantly ignored the device that Congress gave them to shelter themselves. They ignored the safe harbor. The second reason that immunity would be affirmatively harmful today is that it would set a precedent for the future. It would set the example that if the government goes to a private company and asks for that private company's collaboration in a violation of the law, that private company will know in the future that Congress will step in and simply immunize that conduct in the future. And so this is an invitation to continued lawbreaking. This is an invitation to private companies to hand away the keys to Americans' precious privacy rights.
Another argument that I've heard in favor of immunity is that the multiple lawsuits currently pending against these telecommunications companies and the potential for future lawsuits might result in bankrupting some of these telecommunications companies.
The argument that the telecoms could be bankrupted by these lawsuits is nothing short of absurd. And we know this for a couple of reasons. We know, first of all, that the telecoms routinely face multi-million, even billion-dollar judgments. There was a $1 billion judgment against one of the large telecoms just in the last couple of weeks. These companies are sufficiently large that they can absorb these judgments, even if they do happen. And even the prospect of such a judgment is very distant. Any suit would have to succeed not just in a trial court, it would have to go up an appeal, likely to the Supreme Court, potentially a number of times. So any money judgment in these cases is not just manageable, but it is highly speculative.
If the telecommunications companies were able to show in the course of these lawsuits that they had in fact acted with the proper certifications from the government, would that then nullify the lawsuits against them?
If the companies did get compliance certificates from the Attorney General, then several of these suits would result in no money damages for the people who brought the actions. There are some suits in which the certificate protection isn't available, but those are cases in which Congress took a very deliberate decision not to provide a safe harbor. They decided that Americans' privacy interests were sufficiently important to establish a clear and absolute rule. And you have to remember that the telecoms companies are in control, and really between them have a monopoly over the means of passage, the means of carrying all of our telephone calls, all of our emails, routes of communication that implicate necessarily clear privacy interests. And so once we as a community, once we as a nation entrust these companies with communications of this sort, they really have a public obligation to respect the privacy interests of Americans.